All right, Chris Scott, thanks for that update. Important to get a check on the roads, of course. Now, a developing story today. We're taking a closer look at two rulings from the nation's highest court dealing with religious liberty and health care. So first, the Supreme Court ruled Obamacare can stand, leaving the Affordable Care Act in place for millions of Americans and thousands of South Carolinians. Right now, more than 230,000 South Carolinians are covered by health insurance through the ACA. The highest enrollment was back in 2015. Enrollment dropped from 2017 through 2020, but then it grew by more than 6,000 this year. Wow. The second ruling concerns religious liberty. The court ruled the city of Philadelphia cannot cancel a contract with private Catholic charities that turn away same-sex couples who want to foster children. The court ruled the city violated the charity's religious rights by canceling those contracts. And we are going in depth for you this afternoon with both of those cases. Clemson Constitution professor Kevin Vance joining us live this afternoon. And it's good to see you, Dr. Vance. I know we haven't had you on for a little while, so we want to get right to this. Can you break down why the Supreme Court dismissing this challenge to the Affordable Care Act is controversial?
Sure, and great to be here. It's a big day at the court. With the Affordable Care Act case, it was a controversy that goes back to 2011 when the Supreme Court ruled that the Affordable Care Act's mandate that individuals purchase health insurance was not constitutional under the commerce power of Congress, but that it was constitutional under Congress's taxing power. So in other words, the individual mandate was upheld by the court because a majority of the court regarded it as a tax. But after that case, Congress reduced the tax to $0. And some opponents of the ACA argued that the mandate, or maybe the whole law, was actually now unconstitutional and should be struck down since the tax no longer raised revenue and doesn't really seem like a tax anymore.
Behind the court's decision.
So in the fall, the contentious issue at Justice Barrett's confirmation hearing was this healthcare case. And it never seemed likely that the court would strike down the whole law. But in the ruling today, the court didn't even address the real constitutional question of whether or not the individual mandate or the whole ACA are unconstitutional, because it actually held that the party challenging the mandate didn't actually have legal standing to challenge the law in court. So with the tax set at $0, the court majority held that Texas, which is the state challenging the law, wasn't really suffering any real injury by this mandate. And so it didn't have standing to sue.
And what does the ruling mean for people who are insured through the ACA, Dr. Vance?
Because of the court's ruling today dismissing the challenge to the ACA, nothing's going to change right away for people's health insurance as a result of today's decision.
And really, is there anything next for the Affordable Care Act, or are we just kind of keep watching and see what happens from here?
I think nothing immediately will happen as a result of this case, but if it does turn out that individuals aren't purchasing health insurance if they're young and healthy in order to keep rates lower for everyone else, then maybe Congress might one day raise the tax up from $0. And in that case, maybe the court would hear a challenge again. But even then, I suspect the court would uphold the law.
All right, let's turn to that second big case we're talking about today. What kind of effect does the Supreme Court's ruling in Fulton versus Philly have for those adoption agencies really across the country?
Well, it was a surprising decision today because I wasn't expecting it to be unanimous in the sense that all 9 justices sided with Catholic Social Services. But one reason that it was unanimous is because it was a very narrow ruling. And so outside of the city of Philadelphia, which has its own sort of unique laws, I'm not sure that it says a whole lot about how the court would handle other kinds of cases with a similar set of facts. But just by reading the tea leaves, it certainly seems like in the future there would be a majority on the court who would be willing to go much further to protect religious liberty and religious exemptions. So I suspect that religious adoption and foster agencies are probably breathing a lot easier tonight.
Oh yeah, South Carolina does not discriminate when it comes to adoption agencies. What recourse do same-sex couples who maybe are denied adoption by upstate agencies have?
Well, there's always legal recourse, and because this case was so narrowly decided, I think that avenue still remains open to people. But as far as I know, there's no state in which there are no foster or adoption agencies that are willing to work with same-sex couples. Even in the Philadelphia case decided today, Catholic Social Services claimed that it had never actually been approached by a same-sex couple for certification. So because of today's narrow decision, I would guess that probably in the future a same-sex couple would eventually lose if it were to challenge something like what Catholic Social Services did in this particular case. But it's up to the courts. I know that there's a case currently in the federal court system from the upstate in South Carolina dealing with a similar issue. I suspect the religious agency will win, but it could still go the other way in the courts.
Yeah, we'll definitely be watching all of this, these two big rulings today in the Supreme Court. Dr. Vance, we appreciate you breaking that down for us, giving us a little bit more insight. It's so important here. Thanks for joining us this afternoon at 4. We'll see you again soon.
Thanks for having me.